starting in 5 seconds. My interest in basic education goes back to the day when Mahatma Gandhi convened a conference at Vadhva for discussing this subject. A few prominent educationalists and workers in the cause of national education had also been invited to attend this conference. I have been in touch with the progress of this system of education ever since. I am therefore happy to have got this opportunity to come here and speak to you about what I feel about this problem. Although I know I might be repeating the views expressed by me earlier, it is also likely that the views which I express are not in consonance with those of others, particularly of educationalists. Besides, it is also to be seen how far my views fit in with the policy which is being pursued by the central and state governments in this connection, and how far it is practicable to modify that policy. Therefore, I hope what I am going to say will be taken as my personal opinion and that you will discuss it as such with an open mind without fear or favor. It will be agreed that the system of education, right from the first primary class to the highest university course which we are following today, is the same as introduced by the British government in this country. We have not been able to introduce any fundamental change in that system even after the attainment of independence. It is pointless to blame anyone for it because the peaceful manner in which the transfer of power took place made it inevitable that, along with the governmental machinery and other things, the system of education should also come to us as a heritage of the old regime. It is now our duty to give thought to each one of these problems and decide in the light of present day condition how they can be solved, and then to act upon what we have decided. There is no doubt that in introducing this system of education, the principal motive of the British government was to secure as much advantage as possible for establishing itself in this country. The Britishers also thought that, as compared to their own culture and literature, there was nothing much in Indian culture and literature which might be said to be worth preserving. There is no doubt in course of time their views underwent some change. The progress of science in Europe meanwhile confirmed them in their view that scientific education could be imparted only through the medium of English. Consequently, partly for the sake of administrative convenience and partly to propagate their own language and culture, they stick to their own system of education which they introduced in this country. There is no doubt that the education received by our earlier generation was based on this very system. Those people knew little of Indian literature or culture and hardly felt drawn towards it, although a few Indian scholars who were inspired by English education did study Indian literature and wrote a good deal in praise of it. Thus, we find two schools of thought in this country. The followers of one school believes that our own language alone can be the medium of education, and until that is done, education is bound to remain confined to a small section of society and will never spread among the masses. The other school of thought thinks that in this scientific age, our country cannot cut itself adrift from European thought and that at least higher education should continue to be imparted through the medium of English. If that is not done, they argue, we shall fail to pull our weight and lag behind other nations in the race for material progress. These views, as a matter of fact, apply not only to the medium of infrastructure instructions but actually to the whole system of education. Our people have responded more and more to the call of education during the last 50 years, and this is evident from the phenomenal increase in the number of educational institutions. In 1911 12, when Burma and Pakistan were also part of India, there were 186 universities and colleges in India as compared with 537 in 1948-49, though Burma and Pakistan had separated, leaving India smaller in area and population. It is clear from the figures that there is a widespread demand for educational facilities. This demand is no longer confined to towns alone but is evident among the people of the rural areas also. One result of this spread of education has been that many educated people find themselves unemployed. Government jobs and service in private undertakings offer limited openings for the educated. Only a small fraction of successful scholars can be absorbed in them. A large majority of the educated are averse to taking up their parental occupations. As a result of their education, they have lost the capacity to take up those occupations and they are not equipped to follow any other either. Stop. Starting in 5 seconds. Mahatma Gandhi, who had anticipated all this, thought that the system of education, which is so expensive, would not do if education was to be brought within the reach of every Indian, rich or poor. He therefore thought of a new system of education which has come to be known as basic education and which Indian and foreign educational experts have declared to be highly useful. According to Gandhiji, as far as I understood him, there are two basic merits in this new system. Firstly, education under this system is imparted not merely through books but through some kind of practical work so that the knowledge which children acquire will not be the result of mere memorizing but of actual experience. He thought, and some of the leading educationalists were at one with him, that knowledge acquired in this way created a degree of consciousness, efficiency, and a feeling of self reliance, all of which would come handy to one when starting life. Secondly, the other merit in this system, according to him, is that it brings education for all within the pale of practical possibility because of handicraft on which children would be working would bring some return in terms of money which would go at least in part to meet the expenses of their education. He was convinced that unless young scholars made this contribution towards their own education, universal education in India would never be possible. The result of all the discussions and experimentations in the field of education during the last 16 or 17 years is, in my opinion, the same that we arrived at in our discussions in the first conference held at Vadava. Educationists had admitted the utility of the new system but considered children's contribution towards their education as not only impossible but undesirable. Our experience, on the other hand, has demonstrated both the utility as well as the practicability of the system. My remarks are essentially with reference to primary and secondary education. Little has been done so far to apply this system to higher education. It is not therefore possible to say anything about it on the basis of experience. In spite of all that has been done in this field so far, it is a pity that this system has not received the encouragement which it deserved and which we could have given it after achieving independence from the British rule. As far as I can say, the reason is that although the utility of the new system has been proved, our faith in the old system of education remains unshaken. That is also why most of those who are engaged in the work of education have not given much thought to the new system. All that we can say is that even today the new system has not gone beyond the experimental stage. Our government has not decided to popularize it as a part of its constructive program, let alone doing anything practical for it. I know that in the various conferences we have had so far, resolutions have been adopted in favor of it, and government agreed that the new system should be adopted, but actually it has not been done. Consequently, educational institutions of the old type are daily increasing, and whatever budgetary proposals provision government makes under the head education is spent mainly on keeping the old system of education intact. Naturally, the new system has received little encouragement. My own views is that unless fundamental changes are made in the current system, the sad state of affairs that we see today will become sadder. The feeling of discontent among the educated and their utter dissatisfaction with life will continue to grow. I would therefore urge that all those concerned with the education of children, our educationists, universities, and governing bodies of colleges and schools, education ministers, etc., should give not only theoretical consideration to this problem but do something practical to change the present system of education. Unless this is done, the problem would become more and more complicated. I am very happy that the Talimi Sangh has been carrying on its work untreated by difficulties. I cannot say that its activities have influenced educational trends in the country to any considerable extent, but I must admit that whatever is being done by it is of great value to the country. Its usefulness would be realized when sooner or later, compelled by circumstances, we shall have to introduce fundamental changes in the system obtaining today. At that time, the experience acquired by workers of the Talimi Sangh will come handy. As I said earlier, our experiment in the sphere of primary and secondary education has been successful, and we can confidently recommend the new system to our countrymen at these two stages. we cannot say the same in respect of higher education in view of the inadequacy of our experience. Therefore, I attach great importance to your work. I hope the unfavorable atmosphere will not detract your workers and they would continue to do their jobs. Stop. Starting in 5 seconds. Mr. Chairman, sir, I rise to support the demands of the Minister of Education, Social Welfare and Culture. I have always stood for certain values. Education has always been a moving spirit in the reconstruction of the nation. In all the developing countries of the world, the national leaders have always been the students of the universities. Educated men are like drivers of a bus who can see farther away than the driver of the car. I have always pleaded that there should be uniformity in education. Education should be within the easy reach of everybody. I say this because there are a number of public schools and everybody cannot afford to get public school education. There should be compulsory education up to the age of 14 and the boys and the girls regardless of caste, creed or religion should be screened and provided all help. Equal opportunities should be given to all sections of the community. Education is the greatest instrument for national integration. It is the greatest force behind the new education program of our Prime Minister. Educational institutions are like workshops where characters are built and minds are molded. We want men of character. Therefore, education in our schools should aim at developing character. I have to point out that our country's educational system has always been governed by trial and error. We find that changes are made frequently. There should be a consistent system of education right from the primary stage. It is not just like picking up a flower from one bush and leaves from another and expecting the combination to grow into a living plant. It does not work that way. If there is no uniform standard of education, it will be difficult for students of a university in one state to get admission in a university in another state or within the same state. There is also a proposal to hold the Union Public Service Commission examinations in regional languages. I am afraid that with the present fabric of national character based on regionalism, it will be a retarding effect on our national efforts because if Tamil is supposed to be the medium of examination, then a Tamil examiner will always be interested in having the maximum intake from Tamil Nadu. Bengalis will prefer Bengalis and so on. Obviously, it will mean a reduction in standards. There will be no uniformity in the list of the new education program of our Prime Minister, in which the maximum emphasis has been laid on the development of the weaker sections of the society. I would like to know the proposals of the Ministry of Education in this direction for the scheduled castes and scheduled tribes. Have they brought vocational and technical education in the undercharge field of training within the easy reach of the scheduled castes and scheduled tribes? What we know and we find in practice that there are certain sectors where the scheduled castes and scheduled tribes are not at all trained, and although the posts are always invariably reserved for scheduled castes and scheduled tribes, they finally report that no candidate from the scheduled castes or scheduled tribes has emerged. The educational minister therefore will have to say seriously think of having training of scheduled castes and tribes, and for that matter of the weaker sections of the society and the community as a whole, in different undercharged field of training, even where candidates belonging to the scheduled castes and scheduled tribes are available in abundance. They report that no suitable candidate is available. That is why I again plead that there should be uniform standard of education throughout the country in all the universities and in all states. Then, if possible, education should be made a central subject. Now I come to the Department of Sports. Before I deal with the subject of sports, I would like to draw the attention of the Education Minister to 2 points, one of which relates to the Ministry of Education and the other to the Department of Culture, to commemorate the memory of a great scientist of our country, the late Professor Bose, who is no more with us. An institute has been formed in Calcutta. I think the Education Minister is well aware of the fact that, in spite of the formation of this institute, sufficient funds have not been allotted to it either by the University Grants Commission or the central government to run that institution in a manner which was the dream of the late Professor Bose. I wish and hope that the Education Minister will take note of it. Having made these two requests, I will now deal with the subject of sports, which is not properly looked after in our country. We are a country with one fifth of the population of the world, a country which is well advanced in science, technology, and electronics, a country which is under the leadership of the very able Prime Minister who is well known throughout the world, yet the standard of sports here is gloomy. Stop. Starting in 5 seconds. The plaintiffs claim that the Indian defendant number 2 company is under the control of wrongdoers. They further claim that defendant numbers 8 to 10 were in active collusion with defendant numbers 3 to 7, and that they have joined hands to deprive defendant number 2 of its beneficial interest in the suit share, namely 6% of shares of the Indian company. The plaintiffs have further stated that they came to know from newspaper reports that the equity of defendant number 1 was to be sold to private equity investors through a bidding process, and that defendant numbers 3 to 7 along with the defendant numbers 8 to 9 were attempting to sell their investments in the Indian company. It was urged that in case such a sale was to happen, defendant number 2, which had financed the purchase of such shares, would be put to loss if its beneficial interest was not recorded in the books of the Indian company. While filing the suit, and the plaintiffs had filed application number 292 of 2018 seeking leave to institute the suit within the jurisdiction of the High Court of Judicature at Madras. In the affidavit filed in support of that application, the plaintiffs had stated that they had sought a declaration that defendant number 2 had a beneficial interest over 6% of shares of the Indian company. However, the shares might be alienated. It was further stated that substantial part of the cause of action arose within the jurisdiction of the court where the registered office of the first defendant was located and where it carried on business. Further, the entire subject matter of the suit was the shares of the Indian company which are held by defendant numbers 3 to 7, and that defendant numbers 3, 5, 6 and 7 normally reside in Chennai. It was further stated that the correspondences between the plaintiff number 2 and the Indian company through defendant number 10 also took place in Chennai, claiming on this basis that substantial part of the cause of action arose within the jurisdiction of the High Court. Leave to institute the suit was sought. The single judge court granted leave. As noted above, the contested defendants filed applications for revocation of the order granting leave to the plaintiffs. The Indian company in the affidavit filed in support of A number 1387 of 2018. It was urged that order granting leave should be revoked on this ground itself. It was further stated that there are no disputes with respect to the ownership or management or shareholding of the Indian company. It also took the stand that the plaintiffs are neither the shareholder nor the directors of the Indian company, and therefore they had no right to sue, and consequently the suit itself is not maintainable. It also averred that the disputes between the plaintiffs and defendant numbers 3 to 7 arose around 2013, and the suit had only been filed in the year 2018, and consequently the suit was barred by limitation. Another objection was that the plaintiffs had filed the suit when private equity investors had shown interest in purchasing shares of the Indian company, and the same was an abuse of process of law. Maintainability of the suit was also questioned on the ground that it was barred by Section 89 of the Companies Act 2013 and Section 180C 7C of the Companies Act 1956. Somewhat similar stand was taken by other contesting defendants in supporting of the prayer for revoking the leave and to rejecting the plaint in CS number 33 of 2018. Defendant number 2 also took the plea that it was not interested in seeking the relief claimed in the plaint. Defendant number 2 is the beneficial interest holder of 6% of shares of the Indian company. Counter affidavits were filed by the plaintiffs with respect to these applications, reiterating that they had the locus that the suit is within the period of limitation, that the court had jurisdiction to adjudicate the issues, and that the suit that had been filed with bona fide intent. The learned single judge dismissed the applications filed by the defendants seeking to revoke the leave granted to institute the suit and to reject the plaint inter alia, holding that the allegations pertaining to fraud would have to be decided in the suit. He further observed that there were factual issues that were to be gone into, and sections 187C and 89 of the Companies Act, which may be bar the reliefs but would not bar the suit. The aforesaid order of the learned single judge has been reversed by the division bench wide common judgment dated August 03, 2018. It has allowed the appeals filed by the contesting defendants and set aside the common order of the single judge, thereby revoking the leave granted by the single judge in the case. Stop. Starting in 5 seconds. In the light of the legal position stated herein above, it is very clear that no tax on the sale or purchase of goods can be imposed by any states when the transaction of sale or purchase takes place in the course of import of goods into or export of the goods out of the territory of India. Thus, if any transaction of sales or purchase takes place when the goods are being imported in India or they are being exported from India, no state can impose any tax thereon. Section 5 of the Central Act deals with the transaction which is said to have taken place in the course of import or export. Relevant portion of Section 5 of the Central Act reads as a sale or purchase of goods shall be deemed to take place in the course of the import of the goods into the territory of India only if the sales or purchase either occasions such import or is affected by a transfer of documents of titles to the goods before goods have crossed the customs frontier of India. Upon perusal of the aforestated provision of Section 5 of the Central Act, it is clear that a sale or purchase of goods shall be deemed to take place in the course of import of the goods into the territory of India only if sale or purchase takes place before the goods have crossed the custom frontier of India. Looking to the aforestated legal position, it cannot disputed that the goods sold at duty-free shops owned by the appellant would be said to have been sold before the goods crossed the custom frontier of India, as it is not in dispute that the duty-free shops of the appellant situated at the international airport of Bengaluru are beyond the customs frontier of India. They are not within the custom frontier of India. If this is the factual and legal position, in our opinion, looking to the provisions of Article 286 of the Constitution, the state of Karnataka has no right to tax any such transaction which takes place at the duty-free shops owned by the appellant which are not within the custom frontier of India. Looking to the aforestated simple and factual legal position, in our opinion, it would not be much useful to discuss the judgments which have been referred to. In our opinion, the legal position is so clear that it was not necessary for the learned counsel to refer to any judgment, and merely by showing the aforestated factual aspect and legal provisions to the concerned authority, the appellant could have convinced the concerned authority that the sale effected at the duty-free shops of the appellant could not have been taxed by the state of Karnataka. Learned counsel appearing for the respondent authorities had vehemently submitted that the appellant had not exhausted equal efficacy alternative statutory remedy, and therefore the single judge of the High Court had rightly not entertained the petition filed by the appellant. According to them, the division bench had also rightly dismissed the appeal of the same reason. According to them, this court also should not entertain this appeal. It is true that the appellant had rushed to the High Court without exhausting equal efficacious alternatives statutory remedy. In our opinion, the learned single judge of the High Court was also right when he directed the appellant to move the statutory appellate authority. In normal circumstances, even we would have expressed the same opinion, but looking to the fact that the special leave petition has already been admitted and the matter pertains to the assessment year 2004-2005, it would not be in the interest of the justice to relegate the appellant to the statutory authorities, especially when the legal position is very clear and the law is also in favor of the appellant. The learned counsel appearing for the respondent had submitted that the sale would not be taxed under the Act only if it occasions in the course of import, but the transactions of sale which are subject matter of this litigation had not taken place in the course of import, and therefore they would not be exempted under the provisions of Section 5 of the Central Act. In our opinion, the aforestated submission cannot be sustained. They again submitted that in the course of import means the transaction ought to have taken place beyond the territories of India and not within the geographical territory of India. We do not agree with the said submission. When any transaction takes place outside the customs frontier of India, the transaction would be said to have taken place outside India, though the transaction might take place within India, but technically looking to the provisions of Section 2 bracket 11 of the Customs Act and Article 286 of the Constitution, the said transaction would be said to have taken place outside India, the goods that are imported into the territory of India. Stop. Starting in 5 seconds. Sir, as the Honorable Minister has already made it clear that this bill has been brought forward for our consideration after due consultation with the central trade unions, and this bill has been necessitated by the fact that the amendment in the Industrial Disputes Act in 1982 exclude the workers in hospitals and other educational institutions from the purview of the Act. This means that a hospital or an educational institute cannot be called an industry, and if it cannot be called an industry, all those who are working in those institutions cannot get the benefit from the Industrial Disputes Act of any kind. So, naturally, something has to be done for all those employees of such institutions for the redressal of their grievances. It is exactly for this that this bill has been brought before us for our consideration. As regard this bill, there is a provision for setting up of a grievances redressal authority and appellate authority in all establishments for the redressal of industrial disputes. As regards the collective grievances, management council are proposed to be there. Naturally, this has to be done by employer or by those who actually are managing those institutions. If the government is the proprietor, then the government has to do it. If it is a private hospital or a private educational institution, whoever is the employer has to do it, and doing it has been made statutory by this bill. It will be the bounden duty to evolve such machinery for redressal of the grievances of the employees and other employees therein. So, since this bill has been brought forth in consultation with the concerned central trade unions, there is not much to oppose the content of this bill. We can, of course, earnestly hope that, as contemplated in the bill itself, very soon these appellate authority or grievance redressal authority or management council will be established in all such institutions, so that all those who are working therein may be able to get their genuine grievances redressed. As a matter of fact, last year our CGHS doctors went on strike in Delhi. Similarly, the PCMS doctors in Punjab also went on agitation. Somehow, these doctors, whether it is this state or that state, have been agitating and going on strike. Why do they go on strike? As a matter of fact, they do not enjoy the right to strike, just as university teachers, about whom I made a special mention today only. Again, they are going to agitate. Why do they go on strike? Although they do not have the right to strike, why do they go on strike? This is what I am saying. You listen to me. They go to strike compelled by circumstances when they are not able to get justice, economic and social, due to them, then whether you give them the right to strike or not, whether it is on the statute books or not, the workers, the wage earners must take that action ultimately. You cannot check them, and you have not been able to check them. After all, you have to come to terms with them. An agreement was signed, an accord was there in the case of university teachers, but that accord has not been implemented as yet. Those universities teachers and employees are also covered under this bill. That is why I am mentioning this. As regards doctors, of course, much has been done to give them justice. Still, they are not happy. It is the attempts of the government to keep the medical institutions, the educational institutions, free from conflict as far as possible, so that they do not have to agitate every now and then, and there is an alternative mechanism provided for where they can take their grievances. As regards individual grievances, of course, you go on strike for collective grievances, not for individual grievances. The grievance redressal authority for the appellate authority that is being provided for is all right. It is only in the case of collective grievances that trade union activity comes into the picture, but that also comes into the picture if necessary. Otherwise, if the collective grievances can also be met through negotiations, through arbitration, and in other ways, then the question of direct action may not arise at all. So, at least so far as individual grievances are concerned, this will go a long way in settling them and keeping the working force happy. As regards collective grievances, also, I personally think that the mechanism that is now being provided for will go a long way to eliminate conflicts. What I mean to say is that so far as hospitals are concerned or educational institutions are concerned, I would request the government to make all possible efforts to extend the justice due to them. They must have justice if they can get it, like other personnel in services. Stop. Starting in 5 seconds. Sir, I would first like to congratulate you on the short presentation that you gave. Some of the pieces were extremely powerful and they go home very hard. It just shows what one can do if one puts one's energies in a particular direction, the right direction. In India today, perhaps in the world today, we are facing a period of change, the like of which has not been seen ever before, partly because of new technologies that are available, but perhaps more than that, because of a new thinking that is taking place around the world. We are for the first time coming out of a mindset which really belongs to past centuries, a mindset which looks at human beings or the world divided up into boxes, into groups, like you just said, of Hindus, Muslims, Sikhs, Christians, and perhaps beyond that, into nations, into ethnic groups, into regions. For the first time, we have started looking at the world, looking at humanity as one integrated whole. We have started realizing that survival does not depend on any one group surviving, it depends on the survival of the whole of humanity. India has played a major role in bringing about this change in thinking. This has been part of our traditional thinking for thousands of years. Gandhiji revived it during the freedom struggle, and during these past 52 years of freedom, we have been struggling hard, first under Panditji, then under Indraji, to bring this new thinking to the world. For the first time during these last few years, we find that global thinking has started to change. At the same time, the old system fights back very hard. There is a tendency on the one hand to look at the worlds as one. There is an equal attempt to keep the old systems continuing with change only projection, presentation, or perception for the benefit of few. We got out of colonialism, but did exploitation, and it did not. The poorer countries, the weaker countries still have a net outflow of wealth. The next phase seems to be getting into economic groups, which is in a sense is no different. It is just a different form of exploitation, so we have to fight that as well. India has given the lead during the last 4 or 5 decades, and India will have to give the lead in the coming years also. But to give the lead, we need to do certain things at home. We need to be strong and clear in our minds about where we want to go. Our strength traditionally has been that we have always looked beyond the material into certain higher values, deeper values, perhaps spiritual values. We have looked beyond immediate gains. We have always tried to work for certain ideals. Today, this basic Indian thinking is coming under very severe attack, partially from you, because the real attack is from the materialistic attitude that is coming into our society. That is why I am glad to be with you here today to try and turn your attention not to just selling but also at your building the nation that we want to build, projecting the ideas and ethos of India across the world. For that, we need to first look within and see what we need to preserve and what the problems are and the difficulties in preserving it. The biggest attack on our traditional thinking, on our culture, on our civilization is from materialism, which is being brought in partly because of growth, development, because people have access to goods and facilities which they do not have access to earlier, because their incomes have grown, because their standards of living have gone up. The way India has grown during these past 8 or 9 years is well behind what we ever have expected. These problems are going to get compounded. I expect our growth rate to increase even more in the coming years. So these pressures will increase even more. Therefore, we must be very clear in our minds about the sort of nation we want to build. The biggest danger in going down a purely materialistic route is that we will ultimately surrender the independence that we won with so much struggle. I see that as the biggest danger. We are independent today, not because we won a battle against the British and sent them home. We are independent today because we have followed certain policies, because we have followed a certain ideology, because at every step that we have taken, we have kept in mind the point that the independence that we won could also be lost very quickly. When I talk about the independence being lost, it is not just a question of being ruled by another state. That is perhaps not the way it happens now at the end of the 20th century. It happens in much subtler ways today. Flexibility in decision making is limited, options are cut, and ultimately you go by a feeling of righteousness. Stop. Starting in 5 seconds. Sir, the entire constitutional fabric of our country has been eroded, is being eroded persistently, deliberately, and almost continuously. Our center state relations are reaching a breaking point. I would appeal to the treasury benches, ponder over them, find out what is wrong. Look to the legitimate grievances of the various sections. It is no use debunking regionalism and crying out against it or saying that it is anti-national, subversive, or wrong for the country. Go into the reason as to why it is happening and why it is rising, why these demands are being made. Then only you shall be able to remedy the situation. Merely cursing your fate or cursing the anti-national forces behind them, which are allegedly operating according to you, you shall not get anywhere. What about the judiciary? We find Supreme Court judges are speaking in public against Supreme Court judges' interference in our judiciary. There has been an erosion of the freedom of judiciary. The executive has taken upon itself powers which have completely ruined the prospect of an independent judiciary in our country. The power of transferring them at the fag end of their career from one corner of India to the other will be used in an oblique manner, as a judge has put it, and for oblique reasons, and it is a threat like the sword of domiciles which is hanging over their head and ruining all prospects of having a fair hearing for the citizen in the last court of appeal against the executive. I come to the press. In the press, I know there are brave and violent people. They fought against this black bill and forced the government to take it back, yet the danger is not over. Government media is being misused deliberately to build up the party as well as personalities, and those who dare to criticize the government are shunted out. They are refused the so-called plums and assignments, and they have faced occasional repression. What has happened to the press commission report? You tabled it on the last day of the last session. After that, we have heard nothing about it. We do not know whether the government are accepting the recommendations, are going to act upon them, are going to implement them. This is one of the most important issues before the country. We have talked horse, Mr. Vice Chairman, in every session about electoral reform. Again, not a word. Last session, we had promises by a number of honorable ministers, Minister of Law and Justice and the Minister of Home Affairs that very soon a comprehensive bill shall be brought before the House. There is no indication in this address that something has been done or a bill is being brought before the House. Why don't you consider electoral reforms as the most urgent piece of political business before the country today? Why don't you see that the entire system has been distorted and it needs to be corrected? Coming to the administration, it is on the point of breakdown. It has shown its inefficiency in many ways, but the primary reason for the inefficiency is the constant reshuffle. Every time you reshuffle the cards, you come up with the same old joker because you cannot have new ones. The same old faces are there. Coupled with this, you have the frequent, arbitrary, unreasonable transfer of officers after 6 months in a place, they are transferred to other places. How can you bring about efficiency in administration with changing ministers engaged in a game of musical changing officers as attendants? That is why the efficiency of the system is going down, and you have in the ranks of the services today a sense of demoralization. Again, I would appeal to the government, please listen to the murmur of discontent among the civil servant. You cannot run the country without the devotion, the dedication, the loyalty, the sincerity, and the patriotism of the civil servant. Can you? And you have neglected them. You have inferred with them politically. You have also permitted the system to be penetrated by or to have linkages with antisocial elements. Look at any government machinery. Telephones do not function, railways do not function, not a single service functions. You call the police, they do not even turn up. Hanging over all this is a shadow of corruption, corruption which is no longer limited to individuals or at the base level, corruption which has been highly centralized, highly institutionalized, which has become well formulated and well organized from the ground and grassroots up to the highest levels in the country. The system is built on corruption. And when the government says, now we shall fight corruption, I dare say they will not. Apart from corruption, there is an air of violence in the country. I am not talking only about the violence which is the normal concomitant of human society. I am talking about state violence. Stop. Starting in 5 seconds. In Om Kumar and others versus Union of India, this court observed that the principle of proportionality was being applied to legislative action in India since 1950. Any challenge to restrictions imposed by the government under Articles 9(2) to 19(6) are tested by courts on the principle of proportionality. Whether restrictions placed are reasonable or not is adjudicated on the basis of appropriate balance between rights guaranteed and the control permissible under Article 19(2) to 19(6). When legislation is challenged on the ground the restrictions placed on the fundamental right is disproportionate, the court conducts a primary review where the state has to justify the necessity of restricting the fundamental rights. Proportionality involves balancing test and necessity test. The balancing test relates to scrutiny of excessive, onerous penalties or infringement of rights or interest and a manifest imbalance of relevant considerations, whereas the necessity test requires infringement of human rights in question to be but the least restrictive alternative. According to legal experts, proportionality in the broad sense is based on two principal components. The first is legality, which requires that the limitation be prescribed by law. The second is legitimacy, which is fulfilled by compliance with the requirements of proportionality in the regular sense. Its concern is with the conditions that justifies the limitation of a constitutional right by a law. There are two main justificatory conditions: an appropriate goal and proportionate means. An appropriate goal is a threshold requirement, and in determining it, no consideration is given to the means utilized by the law for attaining the goal. A goal is appropriate even if the means of attaining it is or not. The proportionate means must comply with three secondary criteria: a national rational connection between the appropriate goal and the means utilized by the law in attain it; b. the goal cannot be achieved by means that are less restrictive of the constitutional right; c. there must be a proportionate balance between the social benefit of realizing the appropriate goal and the harm caused to the right. The three tests of proportionality propounded by Dickinson in R versus Ox are: a. the measures adopted must be rationally connected to the objective; b. the means should impair as little as possible the right or freedom in question; c. there must be a proportionality between the effects of the measures and the objective. K. Shikri, Justice in Modern Dental College and Research Center and others versus State of Madhya Pradesh, remarked that the doctrine of proportionality is enshrined in Article 19 itself. He explained that the expression restrictions seek to strike a balance between the freedom guaranteed in Article 19 bracket 1 and social control permitted by Article 19 bracket 2 to 19 bracket 6. It was further held in Modern Dental College and Research Center and others versus State of Madhya Pradesh that limitations imposed on the enjoyment of a right guaranteed under the Constitution should not be arbitrary or excessive to what is required in the interest of public. It is also relevant to refer to the following factors which have to be kept in mind for examining the reasonableness of a statutory provision as laid down in MRF Limited versus Inspector Kerala Government. The basis of various decisions of this court, the following principles are clearly discernible. While considering the reasonableness of the restrictions, the court has to keep in mind the directive principles of state policy. Restrictions must not be arbitrary or of an excessive nature so as to go beyond the requirement of the interest of the general public. In order to judge the reasonableness of the restrictions, no abstract or general pattern or a fixed principle can be laid down so as to be of universal application, and the same will vary from case to case, as also with regard to changing conditions, values of human life, social philosophy of the constitution, prevailing conditions, and the surrounding circumstances. A just balance has to be struck between the restrictions imposed and the social control envisaged by clause 6 of Article 19. prevailing social values as also social needs which are intended to be satisfied by restrictions have to be borne in mind. There must be a direct and proximate nexus or a reasonable connection between the restrictions imposed and the object sought to be achieved. If there is a direct nexus between the restrictions and the object of the act, then a strong presumption in favor of the constitutionality of the act will naturally arise. It is pertinent to refer to the observations made by Justice M. Jagannatha Rao in Om Kumar and others versus Union of India regarding proportionality in connection with Article 14 of the Constitution of India, which are as under. So far as Article 14 is concerned, the courts in India examined whether the classification was based on intelligibility differentia and whether the differentia had a reasonable nexus with the object of the legislation. Obviously, when the court considered the question whether the classification was based on intelligible differentia, the courts were examining the validity of the differences and the adequacy of the differences. Stop.